Makadii mose muri Zimbabwe kusangana zvekare pano pachivhitivhiti chenyu patinenge tichikupanya nematest updates anenge achiitika munyika yeZimbabwe. Nhasi tauya takabata audio ine conversation yaProfesa Jonathan Moyo vachitaura mashoko sezvo vari ndo vari kupomerwa mhosva yekuti ndo vari kubatsiridza panyaya yekuda kuita kuconstitution yenyika yeZimbabwe. Saka toda kuti muzvinzwire vachitaura vega, but after izvozvo pane vamwe justice vatange tiinavo paconversation yacho vatoda kuti tikupei zvekare after this video. Muchatera mavidhio aya maviri muchanzwa kuti pane nyaya dziri kutaurika dzakakosha ipapo. So Jonathan Moyo nyaya yese achataura apa pane nyaya dzaacharangaridzwa pa the second video ratichaita part 2 yacho. Saka toda kuti murambe makateerera munzwe iye kuti ari kutaura kuti chipa chake panyaya yekuchinjwa kweconstitution pazvese zviri kuitika panyaya yeconstitution. So ndoda kuti muteerere kubva kumashoko ake kumuromo wake direct panapa, watch live. So ndoda kuti munge makamuteerera muchinzwa zvaari kutaura.
Time before the amendment. I emphasize, colleagues, this applies to an amendment to a term limit provision. It's not only term limit provisions that talk about time. There are many other provisions in the Constitution which are not term limit provisions, but which have something to do with time. An example being Section 95, subsection 2B, and Section 143, subsection 1, or even Section 158, subsection 1. But we have to be clear. The operative phrase in Section 3287 is that the affected amendments must be a term limit provision, not any other. And subsection 1 of Section 328 provides that a term limit provision means a provision of this Constitution which limits, the provision must limit, which limits the length of time that a person may hold or occupy office. If the provision talks about time, but does not limit, does not put a cap on the time, then that provision is not a term limit provision. For a clause or section of the Constitution to qualify as a term limit provision, it must expressly and unambiguously put a limit or a cap on the time that a person may hold or occupy the office. If there is no limit or cap in that provision being looked at, then that clause or section is not a term limit provision as contemplated in Section 3281. Using dictionary definitions of the words term and period, the Constitutional Court, in the landmark case of Max Mupungu versus Minister of Justice, Legal and Parliamentary Affairs and 6 others, held that, I quote, a term is defined as a fixed or limited period for which something, for example, office, imprisonment, or investment lasts or is intended to last, while a period is defined to mean a particular length or portion of time. In other words, in the language of Section 143, subsection 1, a duration of time of Parliament is a period. In light of these definitions, a term is a period. This is in the Mupungu judgment. In the light of these definitions, a term is a period of time which is ordinarily measured by using a particular unit of time and which has a known beginning and a determinable end. The operative word is that, unlike a period or a duration which might be subject to contingencies such as age or election cycle, which can't be fixed exactly unless you are in jurisdictions like in the United States, where it is known that every 2 years, the first week of November has national elections, congressional elections, for example. If an election cycle is provided subject to and so forth, his contingencies, then it is a duration which is not or which does not have a known beginning and a determinable end. Therefore, a term limit in this understanding is a cap on that known beginning, a beginning which is known and an end which is determinable. As such, term limit provisions place a measurable lid on tenure with unyielding limits like non-renewable term, renewable once, not more than 2 terms, or total such as up to a maximum of 2 terms, or renewable once subject to competence and performance, and so forth. All term limit provisions in the Constitution, the 15, guarantee no endless or contingent extensions. They guarantee specific ends, not the kinds that are endless, open, or contingent. Fifthly and lastly, the following stands to reason from the foregoing. One, the bill does not alter or change the presidential term limit in Section 91, subsection 2. Two, there's no third term or the repeal of the presidential term limit. Three, there's no extension of the presidential term which can be done only in Section 91, subsection 2, which is not included in the bill. Four, Sections 95, subsection 2B and 143, subsection 1 are election cycle provisions, and they are critical for that purpose. And they are found in all governments, systems governments, democratic, monarch, or communist, and so forth. They all define the period between the election of one president or a head of executive and the next, or the legislature. It is crucial, not just as a matter of public law or constitutional law, but as a matter of civics 101, to know what is the election cycle of the government, the elective part of the government. It's an important civics lesson. And that's why, in our case, we didn't introduce these sections 95 subsection 2B in and 143 subsection 1 in 2013. We introduced them in 1980. We had them throughout the 37 Mugabe years. Why? Because for sections 95 subsection 2B and 143 subsection 1 are election cycle provisions, not term limit provisions, and they do not belong to the protected category of term limit provisions that require a referendum. 5, there is no implication arising from section 3287 because that section only affects term limit provisions and not non-term limit provisions, which are amended in the bill. 6, the bill only lengthens the election cycle from 5 to 7 years to break the toxicity of a permanent election mode in between elections. It's a Sabbath solution which everyone in Zimbabwe has had, from the churches who came up with a Sabbath proposal in 2021 to NTA who have their own Sabbath proposal, and it is in the body politic. The Sabbath proposal is in the psyche of any and everyone who has bothered to reflect on this proposal. It is not conjured up in thin or from thin air. And it is important to say that as far as election cycles are concerned, the minimum is 2 years for legislative people. And the maximum that is practiced by various jurisdictions as we speak is 10 years. 4 or 5 years is the medium. But there's a lot of literature and at some appropriate time, we will share this literature, which shows that many countries, African countries, which now are seriously grappling with the infrastructural policies and projects, which rely on presidential systems where there's the divisive direct elections and so forth, are reviewing this. We are not the only ones who are reviewing this. And as recent as in September, last September, Guinea made this transition to 7 years. So the bill number 7, the bill is not about the president. It is about the presidency and about parliament as institutions, not members of parliament, not the president. And for the avoidance of doubt, in order to understand that section 95(2)(b) is not a term limit provision affecting the president. Consider this scenario. A presidential successor under section 101, following, say, a resignation of the incumbent or removal or a death of an incumbent after they've served, say, for 2 years. When that happens, the successor assumes only the remaining period of the term of the election cycle. If the election cycle is 5 years and the incumbent goes after 2 years, the successor just serves for 3 years. And this ensures continuity of the cycle without restarting the clock or a fresh term. This alone should settle the question that the period of 5 years does not belong to the office holder. It belongs to the office and can be held by many or several office holders. The same scenario is true in connection with a parliamentary by-election following a vacancy. In line with parliamentary term of office in section 143(1), they fill the by-elections, they fill only the remaining election cycle time. One does not win a by-election to demand a full 5-year term. They win a by-election to serve a term started by the person who caused a vacancy for whatever reason but couldn't continue. I say again, if we are really serious, this should settle the question, because it's so clear that in both the case of the presidency, as described in section 95(2)(b), and in the case of parliament, as described in 143, we are talking about a term of office, not a term of officer. The terms of officers are described elsewhere. For the president in section 91, subsection 2, for parliament in sections 121, 125, and 129. For parliament, you don't find any term limit whatsoever. For president, you do, and it is in section 91, subsection 2. Parliamentary election of the president will therefore, in my view, as proposed in the amendment or in the bill, shield the office of the president from those ills which I summarized in terms of the two-fold elements, which cause polarization, which paralyze policy making, breed endless disputes, and these have bedeviled our country with respect to presidential elections since the advent of those elections in 1990. And the indirect election will promote and strengthen national unity to give everyone and all communities, and I emphasize all communities, a voice in national governance through their representatives in parliament, in line with the section 3, subsection 2A of our constitution, which provides that the principles of good governance which bind the state and all institutions and agencies of government at every level include a multi-party democratic political system, which right now is at conflict, is not there. You can't have a multi-party democratic system when everything else speaks to it, but the most important office in the land doesn't do so. It creates a completely different process and structure. The direct election of the president is in direct conflict with the founding value and principle of good governance enshrined in Section 3 of the Constitution. It is my considered view, therefore, Ndebele and Nonhlanhla, as I conclude, that President Mugabe and his cabinet on this score of the bill deserve unqualified national commendation for coming up with the bill. It has taken quite some boldness. We didn't have it in 2013. People just made a compromise and took lock, stock, and barrel a self-evidently unworkable structure which has caused the government to have a constitutional commission in 2000. So on account of this progressive bill, in my opinion, we have to commend the government for coming up with it. In advancing the bold initiative, they have signaled a historic transformation that honorably reconciles Zimbabwe's troubled past with a promising future of real developmental progress beyond 2030. They are affected because they are the ones who are doing it, but it is the future players who are undoubtedly going to benefit from this and who will have the opportunity to improve it and make it even better. I thank you.